We all know if it isn't in writing, it didn't happen. And contracts are no different. They're the foundation of any successful business deal. They prevent misunderstandings, they protect your interest, and they minimize risk. So in today's episode, we're going to discuss the importance of contracts, what a breach of contract is, and we're also going to share real-world examples, including legal battles between big names like Flo Rida, NSYNC, and Disney. Tune in and let us know what you think. Hey, lady bosses, are you working even after putting the kids to bed but still not getting results?
Are you tired of spending money on ads that aren't getting engagement?
Do you feel burdened that you aren't fulfilling your purpose in life because you are so consumed with work?
I'm your host, Brooke Bolts. I'm an attorney and founder of Bolts Legal. I started my business and in 1 year was bringing in 7 figures and am now bringing in multi-7 figures.
And I'm your co-host, Rachel Bolts, owner of Bolts Media. I've helped many businesses build their online presence and increase their revenue through digital marketing.
Want to hear how we did it?
We are here to help you achieve your goals personally, professionally, and spiritually.
So kick off your high heels, sit back, and let's ignite that passion.
We're Miss Biz, where we're putting the miss in biz.
Let's get biz done. I have been avoiding today's topic. I don't know why. It's breach of contract and contract law. And this is what I do every day. I handle breach of contract cases. I read contracts every day. But in my mind, it's like taking me back to law school, and also just seems dry and boring to me. And we try so hard to keep our podcast engaging that, to me, talking about contracts is boring. But as Rachel keeps reminding me every week, she's like, we got to do that contract episode. And it is important. So stick with us. We've done our best to try to make it engaging, but these are important principles that you need to know as a business owner.
Yeah, so we're going to break down the basics. So basically, a contract is a legally enforceable agreement. It can be written, oral, or implied, and it's between 2 or more parties. And there are a few key elements that make a contract binding. So the first is the offer. This is the clear proposal outlining what one party is willing to do. Next is the acceptance. So that is the other party's agreement to the offer's terms. And then third is consideration. That's the value exchange where each party gives up or gains in the agreement.
Right. So an example of a contract is an example that I do every day. We are trying to settle a lawsuit. We make a settlement offer of X dollars to resolve the lawsuit for someone's injury claim. And if it's accepted, then case is over. We've reached an agreement. Contract is entered into. And the consideration is that each party has to be benefiting in some way from that agreement. If it's only one side who's benefiting, there's no value exchange.
Right.
Then it's oftentimes not an enforceable contract.
And here's the thing, if you're a new business owner, you never know when you need a contract until you do, buddy. You will find out the hard way, especially if you're not getting paid. So it's definitely worth the investment in looking into how to get a contract made just to protect yourself and your business.
A few red flag things to look for when you're signing contracts that have an impact are, 1, attorney's fees. The law, at least in Florida, is that if there's not a statute or contract that gives you a right to attorney's fees, then you're not entitled to them. So what prevents people a lot of times from being able to try to enforce their contract legally is if the contract doesn't say that you get your attorney's fees paid back for filing this legal action, then you're out of pocket. So if someone did you wrong to the tune of $10,000, but your legal fees are going to cost $20,000, then it doesn't make sense to go filing a breach of contract action. But if your contract gives the right to attorney's fees to the prevailing party, then now it makes it make more sense because you have the potential to recoup your $10,000 plus your $20,000 in attorney's fees. So that's a really important provision to look for. But it works both ways. If you lose that breach of contract, then guess what? You have to pay the other side's attorney's fees. So whoever is the prevailing party is who gets their attorney's fees paid. So it goes both ways.
I think I have some referrals for you. We'll find out. So there are a few different types of contracts. There's a bilateral contract, and that's where both sides make promises. So an example of this would be, I'll design your website and you pay me X amount of dollars. The second example of a contract type is called a unilateral contract. That's where one party promises something in exchange for an action. So I'll offer a reward for anyone who finds my lost dog. The next example is called an expressed contract. That's where the terms are written down in detail. And then there's implied. That is where the agreement is inferred of the party's conduct. So you pay a restaurant's bill, they provide food.
When it comes to the written contract, it's important to look up in your state what contracts are required to be in writing. For example, a real estate contract. In Florida, it must be in writing. You cannot sell a property orally. So certain things you can do orally, some things you cannot, but you can look it up easily enough with a Google search. And when it comes to writing, I remember this from law school, that even writing on the back of a napkin can be enough to be considered an express contract. So it doesn't have to be a formal typed up signed, notarized document. If you write it on the back of a napkin and both sides sign it, that can be enough to create an express contract. Implied contract is based on the conduct. So I had a lawsuit one time I defended, went all the way to trial, where my client was an employer and one of her former employees alleged that she'd not been paid commissions that she'd earned while working. But when we pulled out the employment agreements, when we pulled out the wage agreements and just all the evidence, the only evidence that she was supposed to be paid some commissions was her own statement. There was nothing in writing, and there were no actions that supported that. She'd never been paid commissions during the time she was working there, and just the evidence didn't support her verbal claim. And so we won that trial, and my client was vindicated against the allegation of not paying someone's wages. But it's also a lesson that while you can create an oral contract, it's sometimes hard to enforce those because it's kind of a he said, she said situation many times.
So when in doubt, write it on a napkin or send an email or something to back up your written agreement. It's better than nothing. So contracts, they're super important for your business. Obviously, it's going to provide a lot of clarity and certainty. It's also going to reduce any sort of risk that you might have, maybe not all risk, but a majority of it, to help protect you from financial loss. And it also just looks professional too if you have a contract, especially if that's something that your competitors have or it's a common field for you to have a contract. You're going to want to make sure that you are providing your clients with that. It's really going to save you.
Another red flag thing to look for when you're reviewing contracts is the word arbitration. A lot of people may not know what that means or not understand the significance of it. Where I've seen this recently was signing an agreement at a doctor's office that it said mandatory arbitration. So what that means is if you have a dispute with whoever the other party is, in this case it would be a doctor, let's say that they did some medical malpractice to you in the treatment that they provided, you would not have the right to file a lawsuit against them. Instead, you'd have to go to this alternative dispute resolution called arbitration. Well, what the problem with that is that it's very expensive. Arbitration is a neutral arbitrator or panel of arbitrators who makes the decision on your case. That decision is binding. It cannot be appealed. So if you don't like it, you're out of luck. And guess who pays those arbitrators? In the court system, the judges are paid by the tax dollars, they're paid by the government. Right. But in arbitration, it's private, and so the parties pay the arbitrator's fees. So if an arbitrator spends 10, 20, 30, 40 hours presiding over your case, the parties are going to have to pay that arbitrator's hours. It's split in half, and each side pays half of the arbitrator's fee, but you can see how that adds up really quickly. So even if you get a favorable arbitration award, it's going to get cut down by the amount that you're going to have to pay to the arbitrator, and in some cases your attorney's fees as well. So arbitration clauses are really something to be aware of, but unfortunately you don't often have an option. When you go to the doctor, what are you going to do? Not go to the doctor? Right. Because they put that in there?
And then you're going to go see another doctor who has something very similar in nature to
have the same thing.
Yeah.
Right, they're gonna have the same thing.
They're not dumb.
Right. So those contracts are written one-sided.
Yeah.
When you go somewhere, they're written one-sided so that it benefits them the most. And you just need to be aware of what you're signing so that you can make an informed decision. Right. And not be surprised by it after the fact. You understand, I'm taking the risk that if this doctor commits malpractice, I'm going to have to go through the expensive process of arbitration. But this is one thing to be on the lookout for, because if you're in a context where you do have the ability to negotiate, you may want to cut out that arbitration provision because, like I said, of how expensive it can be.
Boy, for someone who didn't want to do this episode, she is getting fired up. Look at that, the passion.
I'm sure everybody is just riveted.
Oh, I'm sure.
By this conversation.
I'm sure. So,
do you love the Miss Biz podcast?
Because we love you.
Here's 3 things you can do to show your support.
1, write us a review. Apple or Spotify are the best platforms for reviews.
2, join us for our free Friday Zoom calls at 10 a.m. Eastern Standard Time. To RSVP, go to MissBiz.com homepage. Scroll down to Miss Biz Connects and click the link.
3, follow us on social media. Our handle is at Miss Biz Podcast.
As always, thank you for your support.
Basically, a breach of contract occurs when a party fails to uphold their obligations under a legally binding contract. This can involve anything from failing to deliver the goods or the services on time, or to not even paying the agreed upon fees. And they can be categorized as either material or immaterial. You want to go into what those mean?
Sure. Material is important. Immaterial is less important or unimportant. So a material violation is something that severely impacts the other side's ability to benefit from the contract. So a material breach would be, I did your website, you didn't pay me. Mm-hmm. That's important. Immaterial would be a minor violation. So minor violation might be, you did the website, but it was a week late. It wasn't on time.
Right.
It's not as important. So those are the different types of breach of contract.
Yep, and there's 2 main ways that a contract can be breached. So the first one is a anticipatory breach. That's where one party clearly indicates they won't fulfill their obligations before the deadline. And this could be through verbal communication or actions that demonstrate their inability to perform. And then there's actual breach. And an actual breach is when a party fails to perform their duties by the agreed upon deadline without any prior warning.
If you've ever done a construction project, then you know what an anticipatory breach is.
Yes.
They're supposed to meet certain deadlines and certain, accomplish certain things at a certain time, and
yet environmental forces always cause the delay.
There's always something that happens that is allegedly outside of their control, and that usually is in the contract too. It says we agree to meet these deadlines unless there's something that happens outside of our control, and there's so many things that can happen outside of your control. So it's we're probably all familiar with anticipatory breaches, but it's not only about deadlines. These type of breaches can be other things as well. It just applies based on whatever your circumstances may be.
So the consequences of a breach of contract are damages. So monetary compensation awarded, it could be awarded to cover losses suffered due to the breach. And this could be
compensatory.
Yes, thank you. I don't know what. So that aims to restore the non-breaching party to their pre-breach position.
Yeah. So both damages and compensatory are both monetary damages. So basically, if Rachel creates a website for me and I don't pay her, the compensatory damages to put me back in the position that I was is to reimburse me for the $1,000, plus I may be entitled to additional delay damages because I've now been out of a website for 6 months while you were creating it, or it may have taken away from other jobs that you could have been working on. So there may be interest and other types of penalties or damages. You have to go add up all of those things to figure out what the fair amount is. But that's compensatory damages, is putting you back in the position you were before the breach occurred. So that's what we do in lawsuits. We try to put people as best we can back in the position they were. I do a lot of homeowners insurance claims, for example. So a hurricane damages your house, insurance company tells you to pound sand and we're not going to pay for your damages. Then my job is to get the money that was needed to fix the home, put the home back in the condition it was before it got damaged in that hurricane. And there may be additional things that happened because of the delay of the insurance company that we also pursue. So there are other types of damages other than monetary damages. There can be the type of damages to get someone to take action. For example, they're holding on to your private materials and not giving them back. So you could file a lawsuit. There's not money to be exchanged there in that situation, but you're wanting them to be required to give back your materials. Or another common one is a trademark infringement or something like that. You're wanting them to stop using your trademark in their business. Those are other types of, we call them equitable remedies that are available.
And this, folks, this is why she's an attorney, because the level of passion right now that is flowing through her being is so strong. So we're going to have some fun now, and we're going to go through some real life examples of different breaches of contract. So our first example is Flo Rida. He was awarded $82.6 million by a South Florida jury for breach of contract by Celsius Energy Drinks. The lawsuit, which was filed in May 2021, claimed that Celsius violated terms of an endorsement deal with Flo Rida's production company. So Flo Rida, he was the brand ambassador from 2014 until 2018. And during that time, he played an instrumental role in launching a new era for the company's brand development, along with their growth and expansion, and introduced the product to millions in the world. That's what the complaint said. But basically what ended up happening is he took them to court, and Flo Rida, he sought 1% ownership, which was initially promised in the deal, and he was willing to accept stock instead of monetary compensation. And the partnership between Flo Rida and Celsius significantly contributed to the company's growth, which is why he was awarded $82.6 million.
That's a great outcome, because looking at this case, it's tough to prove how much your product grew because of one person's brand partnership, unless there is a direct link where when you go buy Celsius, you put in the code Flo Rida,
right,
or something, then you can track it. But if it's just Celsius is sold at the grocery store, so it's hard to know how many people
saw the advertisement or got it from a concert or somewhere where he was promoting it. I know.
It's hard to prove that. It's hard to prove. So the fact that his attorneys overcame that challenge of being able to show how much Celsius grew because of Flo Rida's efforts is kudos to that attorney, because that would be a tough burden of proof.
You know what really showed me a lot about his character was that he sought the 1% ownership, but was willing to take stock in exchange for it. And despite the legal battle, he was still open to working with them and supporting them in the future. He just wanted his money. He just wanted what he felt he was owed.
Something else to be aware of, and this is important, is when lawsuits are filed, more often than not, we are going after insurance proceeds. The party who's being sued rarely is the party who's actually going to write a check if they lose. It's usually the insurance behind that party. And there are certain things you can get insurance for, and there are certain things you can't. And so in his mind, this type of a lawsuit probably wasn't something that Celsius had insurance to cover them for. So they're going to be paying out of pocket. So Flo Rida is trying to be like, okay, if I bankrupt the business and take all the money that they have, then that's not going to help me either. So what is a way that I can be compensated without bankrupting the business? So that may have been some of the discussion that was going on behind the scenes, but it's also important for you as a business owner to know that even though someone may do you wrong, if there's no insurance to cover it, and that party who did you wrong either went out of business or isn't financially stable, then you may have a hard time finding a lawyer willing to represent you, because they go get you a piece of paper saying that you're owed, but if they don't have the money to pay it, chances are you're not going to get paid.
Yeah, so forget what I said about his character, because that may or may not be true. I'm just kidding. I'm sure Flo Rida is amazing. But it's always good to be aware, because I think a lot of people don't realize or have access to that knowledge.